Hey there, welcome to Huruma Law, your go-to channel for clear, concise and reliable insights into South African law. Whether you're a student professional or everyday citizen, we break down complex legal topics into plain language. No faces, no fluff, just facts, rights and real talk. Subscribe and empower yourself with knowledge that matters. Let's get into it. Topic: Understanding the foundations of South African labour law. Ladies and gentlemen, welcome. Today we embark on a journey to understand the labour laws of our beloved Republic of South Africa. Laws designed to protect workers, promote fairness and build a prosperous society for all. South African labour law is rooted deeply in our constitution, which guarantees every person the right to fair labour practices. These laws embody values such as dignity, equality, freedom and justice. Principles that guide how employers and employees interact. At the heart of our labour framework is the Labour Relations Act, or LRA, enacted to ensure industrial peace through fair treatment, collective bargaining and dispute resolution. Alongside the LRA, several other important laws safeguard workplace conditions, employee rights and employer obligations. Together, they form the backbone of a fair and democratic work environment. Why are these laws important? They protect workers from unfair dismissal and discriminatory practices. They promote safe, healthy, and reasonable working conditions. They guarantee the right to organise unions and bargain collectively. They establish accessible mechanisms to resolve disputes quickly and fairly. They aim to balance the interests of employers and employees for sustainable economic growth. In short, labour law is not only about rules, it is about justice, empowerment and mutual. South Africa's labour laws create a strong framework to protect workers and promote fair, safe and equitable workplaces. Central to this framework is the Labour Relations Act, LRA, which governs relationships between employers, employees and trade unions. It protects your right to join or form unions, engage in collective bargaining and participate in lawful strikes. The LRA also established the CCMA, a body that provides accessible dispute resolution without costly litigation. The Basic Conditions of Employment Act, BCEA, sets essential standards like limiting working hours to 45 per week, ensuring overtime pay and granting paid leave such as annual, sick, maternity, paternity and family responsibility leave. Employers must provide clear contracts and pay slips for transparency. The Employment Equity Act, EEA, prohibits discrimination based on race, gender, disability and more, requiring affirmative action to promote diversity and equal opportunities in the workplace. The Occupational Health and Safety Act, OHSA, mandates employers to maintain safe work environments, protecting employees from harm. The National Minimum Wage Act sets a wage floor, currently R27.58 per hour, 2025, to prevent exploitation. Lastly, the Skills Development Act, SDA, encourages ongoing training, helping workers grow professionally and adapt to economic changes. Together, this robust legislative framework ensures fair labour practices, safeguards worker rights, and fosters safe, equitable workplaces, enabling sustainable economic development across South Africa. Topic 3. Your rights and responsibilities as a worker and employer. Now let's talk clearly about what these laws mean in everyday work life. For workers, right to fair pay. You must be paid at least the minimum wage and receive fair compensation for overtime. Reasonable working hours. Typically, you cannot be required to work more than 45 hours a week with regulated breaks and rest periods. Leave rights. You are entitled to paid annual leave, sick leave, family responsibility leave, and maternity or paternity leave. Safe work environment. You have the right to refuse unsafe work without fear of penalty. Freedom from discrimination. You are protected against unfair treatment based on race, gender, disability, religion, and other grounds. Union membership. You can join a trade union and participate in collective bargaining efforts to improve working conditions. Right to written contracts and pay slips. Employers must provide clear contracts and pay statements. For employers, legal compliance. Employers must register with relevant authorities like SARS, UIF, and pay correct wages and benefits. Maintaining safe workplaces. You must ensure work is conducted safely following OHSA fair termination processes. Employers must have valid reasons and follow fair procedures before dismissing employees. Preventing discrimination. Employers must implement employment equity measures. Record keeping. Proper employment records, contracts, and pay slips should be maintained. Dispute resolution cooperation. Employers must engage with unions and employees to resolve conflicts fairly. Together, these rights and obligations foster respectful and productive workplaces. Topic 4. Resolving disputes and the role of trade unions. Disagreements can arise in any workplace. South African law provides you with accessible tools to resolve conflicts without resorting to courts. The Labour Relations Act established the Commission for Conciliation, Mediation and Arbitration (CCMA), a neutral body where disputes like unfair dismissals, wage arguments, or unfair labour practices are settled efficiently. Dispute resolution process. First, try to resolve issues internally through grievance procedures. If unresolved, refer the dispute to the CCMA or Bargaining Council. The CCMA will facilitate negotiation, conciliation, to help parties agree. If no agreement, arbitration can follow, resulting in binding decisions. Serious cases can escalate to labour courts. Trade unions. Trade unions are your voice collective bargaining to improve wages and conditions. They represent you in disciplinary hearings, negotiate agreements, and can organise strikes following lawful procedures. Unions are legally protected and have rights including workplace access, deduction of membership fees, and participation in bargaining councils. Employers are required to recognise unions under certain conditions and bargain in good faith. Both sides have duties to cooperate and maintain industrial peace. Topic 5. Why understanding labour laws empowers you. Understanding these laws empowers you to know your rights. Awareness protects you from exploitation, unfair dismissal, and discrimination. Fulfill your responsibilities. Both employers and employees knowing their duties supports fairness and trust. Engage effectively. Whether negotiating wages, joining a union, or addressing grievances, knowledge helps you participate confidently. Promote industrial harmony. Fair law application prevents conflicts and builds stable workplaces. Contribute to nation building. Labour laws underpin a just economy where all can prosper. South African labour law is more than legislation. It is a framework to uphold dignity, fairness, and opportunity in the workplace. By understanding and respecting these laws, we all contribute to a stronger, more equitable South Africa. Thank you for your attention and commitment to labour rights. For further information or help, reach out to the Department of Labour, your union representatives, or qualified legal advisors. Empowerment begins with knowledge. Know your rights, exercise them wisely, and respect the law. This information is based on the latest labour law framework in South Africa as of July 2025, including recent amendments to the Labour Relations Act and related statutes. Quick disclaimer, this channel is for your empowerment informational purposes only and does not constitute legal advice. As we are not lawyers, watching these videos doesn't create any attorney-client relationship. We aim to help you identify your issues. However, for legal help specific to your situation, always consult a qualified legal professional in South Africa. Thanks for watching. Hit the subscribe and notification button if you want to see more.